Thanks, Paige. Yes, as many of you probably know, I'm not, in fact, John Beisner. I'm Matthew Shores of the Washington office of OMelveny and Myers, so please don't hold against John anything that I say here today. We're talking first about the category of post-approval disclosures and the duty to warn, and I think that I can begin by agreeing with what Elizabeth will probably say, and that is, generally speaking, most state laws do impose a duty to warn in the post-approval of a pharmaceutical product context. That said, there are more than a half dozen statutes in particular states that do either limit or bar liability findings or punitive damages, depending on what the statute is, in the category of cases involving post-approval disclosures. The ones that are probably most well known at this point are, there's a Michigan statute that's been the subject of pretty extensive litigation, went all the way up to the Supreme Court, not this term but last term, and the court ended up affirming by an equally divided vote, 4-4, the application of a Michigan statute that permits liability only upon a showing that the pharmaceutical company defrauded the FDA. And the issue in that case was whether that showing that permits plaintiffs to establish liability is preempted under the Supreme Court's case in Buckman, where the court unanimously invalidated a fraud on the FDA theory several years before. And so those state statutes are the subject of continued litigation, and indeed the justice who was recused in that case was Chief Justice Roberts, who is probably one of the most solid 2 or 3 votes on preemption issues. So the ongoing viability of preemption defenses in those states is obviously certainly valid and will continue to be litigated on remand and elsewhere. There are also FDA regulations that are specific to the post-approval context. The Federal Food and Drug and Cosmetic Act itself does not have any provisions that specifically address post-approval duties, but it does vest the FDA with authority to promulgate regulations addressing that context, and the FDA has done so. Generally speaking, there are duties to provide, for example, adverse event reports as they surface, and then there are more periodic and annual reports that must be filed even after a drug is approved. And one of the things that those reports needs to address are ongoing safety concerns or concerns with the current labeling of the product. So there are regulations that specifically address this issue. The one that certainly has received the most attention in the litigation context, at least, is what's known as the CBE, or changes being effected provision. That is the provision, at least in some ways, that was at issue in the Wyeth case that you just heard about in the last panel. Just to give a little background on it, generally speaking, and the FDA has certainly said this, probably people up here would quibble over the extent to which it's completely true, but most label changes that are implemented following initial approval are done after consultation between the FDA and the pharmaceutical company. There are some circumstances in which the regulations permit a manufacturer to make a unilateral label change without consulting with the FDA. And what the pharmaceutical company can do in that circumstance is make a label change and then submit to the FDA what that label change is. And even under those circumstances, the FDA can disapprove of that label change if it so desires. But the provision that permits pharmaceutical companies to make those changes unilaterally is called the changes being effected, or CBE provision. One of the arguments that was made in Wyeth was that because of the existence of that CBE provision, it would have been impossible for the drug company to comply with both federal regulations and state law, because CBE was not authorized under the facts of that case. It was not a circumstance that even permitted the pharmaceutical company to utilize that procedure, and therefore it would have been impossible to comply with both federal and state law. And the Supreme Court, as you heard in the last panel, disagreed with that. It found that it would have been possible for the pharmaceutical company to utilize the CBE procedure. I don't want to repeat too much of what was said in the last panel, but I think it is important to note a couple of facts in that case that do bear on the kind of more general issue of what are your post-disclosure, post-approval duties. In that case, the Supreme Court found that the FDA had paid no more than passing attention to the risk at issue, and that there was no evidence in the record that the FDA would have rejected the warning proposed by the plaintiffs in that case. So Justice Stevens said, look, on a record in which you haven't proven that the FDA would have rejected your label change, I think you could have utilized the CBE procedure, and I'm just not convinced, based on the facts that have been put before us, that this is an impossibility situation. I think that that does leave open preemption theories in cases where, for example, the FDA has looked carefully at a risk following approval and has declined to make a label change, or indeed has specifically rejected a label change proposed either by the drug company or perhaps by a third party through a petition. So those cases are still out there, and I don't want to oversell the extent to which Wyeth has foreclosed preemption theories. But the thing that I think is important coming out of Wyeth is not to conflate two different questions. The question that was before the Supreme Court in Wyeth, obviously, was, is this theory preempted by federal law? And the court said no. The CBE procedure and these post-approval disclosure theories implicate a more basic state law question too. And I think it is really important because there's a tendency to think, oh, well, the Supreme Court said you should have done the CBE procedure. That's the end of the story. This whole regulatory defense doesn't work anymore. And I think that's not the right way to look at it after Wyeth. What Wyeth held was the drug company could have, it wasn't impossible, utilized the CBE procedure, but it did not explain or rule out the possibility that choosing not to use the CBE procedure and working with the FDA instead to look at a risk rather than making a unilateral label change was unreasonable as a matter of state law. And so I think what you have coming out of Wyeth and remaining the subject of litigation in any case, even cases in which preemption has been squarely ruled out, is the question, was the company reasonable in doing what it did even if it elected not to utilize the CBE procedure? And the reason I think that's important is a couple things. The first thing is that there may be situations in which there really is no CBE trigger. And what the FDA has said is a trigger for changes being affected is newly acquired information. And so if there is a case in which the sole theory is that the FDA was hoodwinked in approving this product, the drug company did something else wrong prior to approval, that's going to be a tough case for CBE in the future, even after Wyeth, because there just isn't that trigger for the drug company to utilize this unilateral authority to make a changes being affected change to a label. The second reason I think it's important is because the FDA has determined, and Justice Stevens kind of went out of his way to say he wasn't going to rule on the enforceability of these 2008 amendments to the FDCA. He was instead just focusing on what you heard about the 2006 preamble, which was more specific to labels and the effect of labels on state law claims. But what he said was, I'm not going to rule out the possibility that these 2008 amendments to the CBE provision are enforceable. And what those provisions said was, CBE is only appropriate in circumstances where the company decides, or reasonable evidence suggests, that the content of the label must be changed. And the reason that's important is that a lot of times you hear disputes in these cases about the warning section of a label. And under current federal regulatory law, something's only appropriate for inclusion in a warning if there is sufficient evidence from which there is a causal association can be drawn. And I think the regulation says causation need not be definitively proven, but it must be causally associated. And so there's going to be ongoing litigation, even following Wyeth, on the question of, did the evidence that surfaced after approval satisfy that substantive standard for inclusion in the warning section of a label? And if it's not causative evidence, then there's a perfectly valid regulatory defense by the company that it was not appropriate to utilize the CBE provision to address that risk. And the reason this is not at all an academic point, but it's a really practical one, is a lot of this litigation is going to be in cases in which the FDA ends up deciding not to put post-approval information in a warning. And the litigation is essentially, did the FDA get that wrong? Should that have gone into the warning section of the label? And since the FDA has now said CBE can only even be used in situations where the warning section should really be changed, there's going to be a valid defense in that whole category of cases, I think, that the FDA looked at this information following approval. It ultimately decided not to put this information in the warning section. So that proves that the use of CBE in these circumstances would not have been an appropriate exercise, and we now know that because the FDA has reviewed this data and decided to put it somewhere else or decided to phrase it in a different way. And so I think even for all those reasons, following Wyeth, there's going to be ongoing litigation not only about preemption, but how the CBE provision impacts litigation at the state law kind of duty of care level. And there will probably be ongoing battles of experts on application of the CBE provision to the facts of this case, jury instructions on that, and you know, that defense remains robust, I think, following Wyeth.